So, Chris, today we're talking about never events. What is a never event? Is that just a concept that we have, or is there a legal definition of it in Ohio and elsewhere?
Uh, so a never event is something that the Center for Medicare actually came up with, and they're events that occur that have always occurred, but at some point, Medicare decided that because these events should never happen to somebody when they're receiving health care, that they're not going to reimburse the providers that try to bill for those events. So that's where the term never events came from. I mean, they've always existed. They've always been, there's things like bed sores or wrong site surgery or just things that are so far outside the realm of good, safe health care that, from medical malpractice, attorney standpoint, we've always, held people accountable for these types of things. Uh, and the medical field has generally looked the other way when these things happen. But some point in the last 20 years, Medicare started to get serious about it and said, we're no longer going to pay for these mistakes. And they're the ones that actually came up with the term never events, meaning that they're the types of things that should never happen when somebody's receiving medical care. If you ask me, I think they're not. It's not broad enough. It's limited to too many. You know, a certain number of things. But
So, what is your experience with never events in medical malpractice cases, and does it differ from other forms of medical negligence or malpractice in terms of how you approach them?
it does not change our approach. Like I said, we've been trying to hold caregivers responsible for these types of mistakes for I've been doing that for 40 years. It does make it honestly a little easier because it's harder for the defense to go out and hire experts that say, oh well, this was reasonable, or this met the standard of care. When like I said, the caregivers can't. The healthcare treatment is so bad that the caregivers can't even get paid for it by the insurance companies because the insurance companies and Medicare has determined it should never happen. So from that standpoint, it's made it a little easier.
Okay. So if a never event occurs, what are the typical steps that are involved in pursuing a medical malpractice claim? And obviously, I think like what you're saying is that in terms of challenges that you might face for it, a never event is actually a little bit easier to pursue. But nevertheless, what are the steps that need to happen?
Always the first step is to get medical records from the treatment, to see what happened, at least see what the defense is saying happened, or what the hospital caregivers say happened, and then we evaluate that ourselves. We have I've been doing this for 40 years. Know my way through the medical records. We also have a full-time nurse on staff that will go through the records, and if we determine that there was a never event or that something happened that shouldn't have happened, then we have that reviewed by leading experts in the field, and they have to sign an affidavit of merit saying that there was, negligence and that the negligence caused an injury before we can file a case. But those are the initial steps to pursue the case.
And in cases involving never events, what types of damages can be pursued? And are there any caps on damages in Ohio?
Yeah, so anytime there's medical negligence or medical malpractice, patients can always recover the cost of any future medical care that results from the malpractice, and that would cover anything into the future that they would need to make up for the harm that was caused. If the person can no longer work because of the injuries they sustained as a result of negligence, they can recover for lost wages through their expected work life expectancy. Those are the kind of economic or money damages. And then for anything, uh, pain, suffering, changes to the lifestyle, having to go to see doctors, all of that inconvenience and disruption in their life. They can recover for the value of that, and the jury has to determine what the value of that is. Those are called, non-money or non-economic losses. And then if the care is bad enough or shows a flagrant disregard for the rights and safety of patients, then punitive damages can be recovered as well.
How do you typically investigate a never event to determine if there's a valid medical malpractice claim, and what resources do you utilize? And you mentioned that you have a nurse on staff who can help to review medical records. What are other ways like that do you help to determine if you have a case?
Well, in terms of never events, I mean, those are published, by the government. It has a list of these are the never events. We have a pretty vast network of experts that we've consulted. I've been doing this for 40 years, so I've worked with a number of experts in almost every field of medicine. So we consult with them. We also do research on the medicine involved in every case. So, those are basically the resources that we have to use to build our case.
When a never event happens, a hospital might go through a procedure of writing an incident report or doing some sort of an internal investigation themselves. What role do those types of reports and investigations internal to a hospital have on a potential lawsuit?
Well, unfortunately, in Ohio, those reports and investigations, the details investigations aren't discoverable. In other words, the patient is not allowed to find out, if there was an investigation done, what the investigation showed, or what the results of that investigation were. So there's still kind of a blanket of secrecy over what actually happened. Unfortunately, as much as hospitals claim they're transparent, they're not. They hide behind this, it's a statutory privilege. So, we're not able, in most cases, to get any of that information, and we have to do our own investigation.
Any sort of final thoughts on never events, overall, and your approach to them?
Like I said, never events have been around for as long as I've been practicing law. It's good that they're finally being recognized as such. There's still a big push by the hospitals and doctors to not allow the fact that they're never events to be admissible in court. So far, we haven't had that happen, but I know in other cases they've had that, not let the jury hear about the fact that it was a never event. I do think as time goes on and things get more transparent, that there'll be more never events. And, hopefully at some point, hospitals and the insurance companies that insure doctors will just, when there is a never event, just try to resolve those with the patients rather than litigate them. But that's probably wishful thinking on my part. I don't know.